This is Duke University.
Coming today, my name is Katharine Bartlett. I'm on the faculty here, and it's my great pleasure to moderate this panel today, recognizing the 1 year after the repeal of Don't Ask, Don't Tell. This event is being sponsored by the Women's Law Students Association, OutLaw, and the American Constitution Society, and I want to thank those organizations for making this possible. I was asked to introduce this panel with a little historical perspective on the military and civil rights. This is not exactly my area of expertise. There are probably plenty of people in this room who could do it better, but I'm going to say a few words, kind of lay out what I take to be the prevailing narrative, and if the panelists have an opportunity to address that in this context, that would be a plus, I think. So the prevailing, I understand at least that the prevailing narrative is that the military has been at the cutting edge of civil rights in this country. It may not always be the first actor, but the story goes, because of its command structure, it knows how to integrate previously excluded groups better and faster than we do in the rest of society. This certainly seemed to be the case with racial minorities, particularly African Americans, who served largely in segregated units up through World War II, largely because it was assumed that the integration of races in the military would undermine military preparedness. The units would lack cohesion and efficiency. But despite these claims, as you know, President Truman, by executive order in 1948, declared that the military branches would be integrated. He gave clear and unambiguous instructions to the military to make it happen, and it did. It turned out that there were far fewer problems than anticipated, and that the success of the integration of African Americans in the military became a kind of model of racial integration. The message from the top was never as clear or as unambiguous with women as it was with racial minorities, but again, integrating women into the military functions went more smoothly than expected. In the 1970s, there were fewer than 2% of women in the military. They faced quotas, discrimination in assignments and promotion. They were disqualified if they were pregnant or had minor children. In 1968, a federal judge declared that in providing for involuntary service for men and voluntary service for women, Congress follows the teachings of history that if a nation is to survive, men must provide the first line of defense while women keep the home fires burning. So that was kind of the theory of women's exclusion. Women are now about 15% of the military, not a huge number, but quite significant in light of the history. Probably the biggest problem is sexual harassment, and one could hypothesize that this is because the men at the top who are capable of giving clear and unambiguous instructions didn't understand sexual harassment as much as they understood problems about hiring and promotion. That's not the topic of this talk, but it does offer a parallel that in terms of the integration of men and women serving side by side, it didn't turn. The horror stories didn't turn out. The history of integration of gays and lesbians in the military starts out as a different story, and I'm interested in whether the larger narrative fits. But unlike blacks who only served in segregated units, and unlike women who were largely excluded, gays and lesbians have been serving in the military, closeted, long before they were officially integrated. Of course, if their sexual orientation was discovered, they were discharged, and you might not all know that many more women were discharged than men. They represented, even in recent times, represented 15% of the military and 45% of discharges for sexual orientation were of women. We sometimes forget that Don't Ask, Don't Tell enacted early in President Clinton's term, and it's been a policy so long vilified that I think it's maybe not fully appreciated that it was actually an effort to reduce these discharges. A study commissioned by Les Aspin, who was Clinton's Secretary of Defense, found that the number of openly gay service members were small, that they were appropriately circumspect, and that few problems arose from their presence in terms of unit cohesion and all the other arguments that had been used to support their discharge. So the idea of don't ask, don't tell, at least as I understand it, and our panelists will correct this if I was wrong, was that we would be more rational about this strict discharge, and don't ask people and wait to find out. And even when you find out, there were, although there, they had to be supposedly have to be forced to be when it was staring you in the face, then the military had to discharge you. Now, unfortunately, we not only got stuck on don't ask, don't tell, which was supposed to be a step toward a more fully integrated, non-discriminatory military, but that didn't work the way the law was initially envisioned. And I hope that the panelists will speak something about that in terms of presuming conduct from status and so on. So a lot of discharges, as you know, continue to occur, and I understand that there were about 13,000 troops that have been discharged as a result of don't ask, don't tell. Let me stop there and turn this over to the panelists, who will address first kind of how, maybe a little bit about what the problem was with don't ask, don't tell, but primarily how it came about to be repealed, and then secondly, what has happened since its repeal. Our two guests are Dan Woods, who is a very distinguished trial attorney who practices in LA with the Music Peeler firm. Mr. Woods represented the log cabin Republicans in the challenge to don't ask, don't tell. I won't go into all of his bio. He has received an unusual number of recognitions and awards from various bar groups and professional publications. He's one of the top 100 attorneys in California, has a number of Lawyer of the Year awards, and is obviously a very successful practitioner. Also with us today is Kulsoom Naqvi, who's a staff attorney with the Service Members Legal Defense Network, SLDN, and I hope she'll tell us a little bit more about that, or tell us something about that organization. Kulsoom has been very active with a number of organizations and a number of projects relating to the rights of the excluded, including NYU's Immigrants' Rights Clinic and the Open Society Justice Initiative. So I'll start with Dan Woods, who's going to talk to us about kind of the story of don't ask, don't tell and its demise.
Thank you, Professor. It's actually easier for me to stand wearing my new fashion accessory. So I'll come over here. As the professor was explaining, the law that was enacted in Don't Ask, Don't Tell was the first time there was actually a congressional statute on this subject of military service by homosexuals that had previously been done by military regulations. The goal was to allow people to serve if they happened to be of the homosexual status, but was to prevent them from engaging in homosexual conduct while they were serving. And the problem that developed was in the way that the term homosexual conduct was defined. It was defined to include a variety of things that you would expect it to include, but it also included things like holding hands, and it went further and said that anyone who committed an act or a statement that indicated a propensity to engage in homosexual conduct could be discharged. And that act or statement indicating a propensity to engage in homosexual conduct created a rebuttable presumption that you had engaged in homosexual conduct. And that rebuttable presumption was almost impossible to rebut. In fact, the only people who ever really succeeded in doing it used something called the Queen for a Day defense, which went something like this. Yes, I engaged in homosexual conduct last Friday night, but I was drunk, I didn't mean to do it, and I've slept with 24 women during this year. And it was only this one time, and I'll never do it again. And that was basically the only way you could rebut the presumption of this. Anyway, various challenges were brought in court to Don't Ask, Don't Tell. And for many years after the law was enacted, those challenges all failed. In 2003, the Supreme Court decided Lawrence against Texas, which you probably read in constitutional law, which established that there is a constitutional right to private consensual homosexual conduct. And based on the principles of that case, we were approached when I was at a different law firm to represent the log cabin Republicans in a constitutional challenge to Don't Ask, Don't Tell based on the principles enunciated in Lawrence. And we undertook to do that. And the lawsuit took 6 years to get to trial. I don't have time to tell you all of the things that happened in those 6 years, but I'll just tell you a few things that will hopefully explain what happened. So first thing we did was we filed this lawsuit on behalf of the organization, the Log Cabin Republicans, and not as an individual lawsuit. We wanted not to correct the situation for one individual plaintiff, but we were really challenging the entire constitutionality of the statute. So we did it with associational standing, and we did it as a facial challenge, not an as-applied challenge to the constitutionality. The claims that we brought were for due process, equal protection, and First Amendment. Okay? Now, as I said, the case took 6 years to get to trial, and that's because there was a great deal of motion practice. And ours was one of the very few cases to ever get through all of the government's motions to dismiss, motions to stay, motions for summary judgment, and so forth. But we survived all those motions, although we lost our equal protection claim and part of our First Amendment claim, and finally, in the summer of 2010, got to trial. Now, I know that many of you want to be trial lawyers, and many of you have taken or are taking civil procedure and evidence and trial practice classes. And again, I can't summarize a long trial in a few minutes, but I do want to just tell you a few things so you understand that what you're learning here in school can actually really be used in a fun way in a big civil rights trial. Okay? So we obtained and used a lot of documents that we got from the government. So we were able to use at trial documents we obtained from the government showing things like discharges went up in times of peace and down in times of war. Okay? So it's sort of counterintuitive, right? If the notion is you need a law like Don't Ask, Don't Tell for military readiness, you would think it'd be more important when we're at war. It turned out to be exactly the opposite. We found an Army regulation that showed that if somebody was in the process of being investigated for Don't Ask, Don't Tell violations, and even if there was credible evidence to support a charge of a Don't Ask, Don't Tell violation, in other words, homosexual conduct, if that person's unit was being deployed into combat, that person could go, and they deal with the discharge proceedings after he got back or she got back from the foreign combat deployment. That is, of course, if the person got back. Okay? So we had these kinds of things that we were able to find out through document productions and discovery. We also did a very amazing 30B6 deposition of the United States government. Okay? So we asked the United States government to produce witnesses to testify on different topics. And I'll just tell you about one of them. And this was the topic of moral waivers. Okay? There is a law that says a convicted felon cannot join our armed forces. Pretty obvious, right? All right. So while Don't Ask, Don't Tell was in operation, and while 14,000 people were discharged under Don't Ask, Don't Tell, we were fighting 2 wars, and the Army was shorthanded. So the Army adopted a policy of moral waivers so that it could accept people who, in fact, had been convicted of serious crimes, including felonies, including violent offenses. And what we were able to show from this 30B6 deposition was that the government had actually taken into the Army 4,000 convicted felons at the same time that it was discharging homosexuals. So that was pretty important evidence at the trial as it went along. It, in fact, gave me one of the great lines of the closing argument, which was something like this: Your Honor, the evidence showed at this trial that the government would rather give a convicted felon a gun than to give a gay guy a typewriter. And so you don't get to say those things in many trials. But that was one of the tools that we used to prove the case, this 30B6 deposition, and there were other facets of it too. We also used 7 expert witnesses who talked about various aspects of Don't Ask, Don't Tell, the history, the psychology of unit cohesion, the experience of foreign militaries that had recently changed their laws and found that there was no impact on the performance of the militaries in those countries, including England, Australia, Canada, Israel, countries like that. Professor talked about the disproportionate impact of don't ask, don't tell on women. And that was certainly true, and we had expert witnesses testify about that. One of them was, the kind of person that really didn't belong in the Army. This was a woman who had graduated from the Air Force Academy, and her job in the military as an officer was to teach United States history at the Air Force Academy. And she had been married to a male for a while and decided ultimately that that was not her orientation and realized that she really was gay. And she struggled with that because the Air Force oath requires people to be honest. And so she finally came out, and so because she obviously couldn't teach United States history if she was a lesbian, she had to leave the Air Force. She then, of course, went to Yale, where she got a PhD in history and a JD, and is now a professor at Hastings Law School. But anyway, Professor Beth Hillman testified about this phenomenon of the disproportionate impact of don't ask, don't tell on women, and explained it. Caitlin, I see Caitlin here. Can you explain to us why this happened, Caitlin? No, okay, I'll try. I'll try. She explained a phenomenon called lesbian baiting, okay? And it would go something like this. I'm a sergeant in the Air Force, let's just say, and I had Caitlin in my unit, and I asked Caitlin out on a date, and Caitlin says, no way, I'm not going out with you. And I go back to my friends and say, Caitlin wouldn't go out with me, and so my buddies say, well, what do you think? Why wouldn't she go out with you? Well, she wouldn't go out with me. She must be a lesbian. And so people like me in my unit would then go looking for evidence that the woman was a lesbian. And so there were cases that ended up happening where if you go look in her room while she's not around and you found a Melissa Etheridge CD, you laugh, but these are true stories. A photograph of the woman at a Dinah Shore golf tournament, a K.D. Lang poster. These were things that were used to suggest that the person had a propensity to engage in homosexual conduct, and how do you rebut that presumption if you are a homosexual without lying? And so these are the kinds of things that happen. And so we had expert witnesses testify about all of those things too. We also used something you've probably read about in evidence, admissions against interest, party admissions. And so by the time our case got to trial, the delays allowed the Republicans to leave office and President Obama to take office, promising to repeal Don't Ask, Don't Tell. And so since he was catering to the LGBT community and fundraising from them, he was making a number of statements at various events about Don't Ask, Don't Tell. And so we used those statements against the government at the trial. Okay? So I'll just read one of the statements he made. He was at an event and he said, reversing Don't Ask, Don't Tell is essential for our national security. And he also said, preventing patriotic Americans from serving their country weakens our national security. So it's pretty good stuff, right? So we sent the government requests for admissions. You learned about those, right? So admit, number one, that President Obama gave the speech on such and such a date to such and such a group. And the government admits. Admit that in that speech he said, Don't Ask, Don't Tell weakens our national security. They have to admit that, right? So the next one is, admit that Don't Ask, Don't Tell weakens our national security. So the government's flummoxed by this. They don't know what to do. So they object. They can't answer yes because it sinks their case. They can't answer no because it contradicts the president. So they object. So we move to compel an answer, and we win. The government appeals, we win, and they finally have to answer. And they have a big powwow to figure out how they're going to answer this question. And we later learned that the powwow includes White House and White House lawyers, Defense Department lawyers, Justice Department lawyers, and the Solicitor General at the time, Elena Kagan. And we only know this because she had to talk about it at her confirmation hearings. So she's talking at her, so all these people are trying to figure out how to answer a request for admission in this district court case in California. So ultimately they said they denied it. They contradicted the president. But we used all these statements as party admissions. We also used one from Admiral Mullen, who was the chairman of the Joint Chiefs of Staff at the time. Believe it or not, Admiral Mullen had a Twitter account, and he tweeted, "I stand by what I said. Allowing homosexuals to serve openly is the right thing to do. It comes down to integrity." So we offered that into evidence. The government objected that we hadn't laid an adequate foundation for the admission of a tweet. And we had a fight about that. Unfortunately, we had an expert witness testify that his account was a verified Twitter account, and so on, and the evidence was admitted. Anyway, the trial was a lot of fun, and ultimately, as I assume you know, we won. And the judge declared in an 85-page memorandum of opinion that Don't Ask, Don't Tell was unconstitutional. It infringed on the rights of a certain group of people. The infringement on their rights didn't serve an important government purpose, and in any event was not necessary to serve that important government purpose. And so she declared it unconstitutional. Now, all the while, bills had been pending in Congress to repeal Don't Ask, Don't Tell, but they had not gotten very far. So we won this trial in September of 2010, and in October of 2010, we got an injunction, a permanent injunction against the enforcement of Don't Ask, Don't Tell. Now, of course, the government was planning to appeal, but at the same time, the Secretary of Defense, Robert Gates at the time, was quoted as saying, "Wait, I can't have a judge in California tell me how to run my military. I have to be in charge of the military." And so our case prompted, in part, the legislative repeal process that then took on a great deal of momentum. As it turned out, the legislation was passed in December 2010, but it was an odd sort of piece of legislation because it didn't become effective immediately. It became effective, according to the terms of the new statute repealing Don't Ask, Don't Tell, 60 days after the Secretary of Defense, Chairman of the Joint Chiefs of Staff, and the President all certified that the military was ready for repeal to be effective. So, of course, 6 months go by, and nothing has been certified. And then in July of last year, we won a motion in the Ninth Circuit Court of Appeals that allowed for the reinstatement of our injunction, so that after that date, there was in place a permanent injunction against the government from enforcing Don't Ask, Don't Tell. Coincidentally, I'm sure, the government then immediately issued those certifications, and the law became effective 60 days later, 1 year ago today. And then, of course, the government argued that our case was moot, which it was, found to be by the Ninth Circuit. But it was a great thrill, really, to be part of one of the great civil rights issues of our time and to play a part in it. Now, along with this legislative repeal, there are many people who participated in the legislative repeal process, but key among them was the executive director of SLDN, a fellow named Aubrey Sarvis. And there's a really wonderful HBO documentary called The Strange History of Don't Ask, Don't Tell, which is in many ways sort of a Valentine to Aubrey Sarvis for the work he did on the legislative appeal. There's a new book out by one of our witnesses at the trial, a fellow named Alexander Nicholson, about sort of the sausage making of legislative lobbying and things like that. And I don't want to pass the baton along yet, because there's one other thing I want to say, and that is that the real heart of our case at trial were the individual men and women that we called as witnesses to testify about their experiences in the military and their discharges under Don't Ask, Don't Tell. We called a cross-section of people from different branches, both men and women, both officers and enlisted men, and these people were true heroes. And these were the people who were, for example, had flown 61 combat missions in Iraq, but were not really able to converse with his unit mates because they all wanted to ask him, well, do you have a girlfriend? What are you doing this weekend? And things like that, and he couldn't really tell them. So he'd fly a lot of missions and then get off the plane and disappear. And they called him Vapor because he would just go away as soon as he got off. We had another guy who was in the Air Force for 20 years who was discharged, and every single member of his unit said his loss to our unit would weaken our unit, and it did. But he had been found to have sent 12 emails about male relationships. And there were a lot of stories like that, but these people were the heroes. And these are people who really wanted to shave their heads. They wanted to go to boot camp. They wanted to go fight and risk their lives for our country. They didn't want to change the military, they just wanted to be part of it. And that's the reason for the don't ask, don't tell fight. But for more about the legislative process, and then we'll talk about the state of affairs today.
And you can just transition right into it.
Okay, fair enough. So in terms of the legislative process, Mr. Woods is absolutely right. It was very much driven by the litigation, and the military was sort of taken unawares and kind of caught in a way, realizing that there's a very real possibility here that they're not going to have any control over how repeal took place. And that's not something, obviously, that they would have been at all comfortable with. And so that process really helped move forward the litigation, the process in Congress. Originally, it was going to be part of the NDAA for 2010. Things happened in such a way that it ended up not being possible to do it in that venue. Ultimately, it ended up being passed as a standalone bill towards the end of the term. And as a result of that, one thing that did happen was that some of the protections that would have been there for LGB service members were stripped out, in the sense that right now what you had was a repeal of the existing regulation, but you didn't have anything that specifically indicated that there was going to be equal treatment, a policy of non-discrimination in the statute itself. So in terms of how that's actually played out, so far things have been very good. In the last year, we've had an absolutely minuscule number of cases where people have actually experienced discrimination or harassment on the basis of sexual orientation. And in those very rare cases where it has happened, overwhelmingly, the commands have been excellent about stopping the behavior and taking the actions necessary to sort of get that person out of that situation in a way that they're comfortable with, and to prevent that behavior from happening again in that situation. So to the extent that that continues, the fact that there isn't something statutory that protects people on the basis of sexual orientation hasn't become an immediate problem at the moment, but it is something that we would want going forward. Right now, the military does have they've issued a guidance indicating that there's a policy that individuals should not be treated any differently on the basis of sexual orientation, but it's not quite the same thing. So what happens for people who are experiencing these kinds of problems is that they pretty much have to go through their chain of command, or they have to go to the IG in order to make a complaint. So to the extent that there might be a wider spread problem within that area, within that unit, within that base, that could eventually work against people. But so far that hasn't been a problem. So that's just fantastic, and we're very happy with the way it's gone at this point. Now that being said, we do have sort of two tracks that we're working on here to get to a place of full equality. Right now, although repeal is done, although no one can be discharged anymore, there was this period between 1944 and 2011 where people were being discharged. And that huge group of people still have discharge characterizations and paperwork that indicates that they were discharged on that basis. When you're discharged from the military, you get, in most cases, what's called a DD-214. It's a one-page document that kind of summarizes your time in the service, and it gets attached to most job applications that you fill out, and it's a it's the basis for giving you all kinds of different benefits that you should be entitled to through the VA. These documents, for people who were discharged before Don't Ask, Don't Tell, a very large number of the people who received discharges got something less than what they deserved, in the sense that ordinarily, if you do your job, if you do it well, you get an honorable discharge. If you don't, then you get a general, or other than honorable, something less than that. Most people who were discharged before Don't Ask, Don't Tell didn't quite receive that honorable. In some cases, it was an undesirable discharge. In some cases, it was other than honorable. And that shuts you out from a lot of those benefits. GI Bills, being able to access VA hospitals, things like that.
Burials.
Yeah, well, yeah, in some cases. So basically, that's something that kind of follows you through your life in that way. And particularly in an employment context, I mean, it's an indication that for whatever period of time, someone didn't think that you did a very good job. So that can seriously impact your ability to sort of move forward with your life, as well as a dignitary aspect of it. A lot of people, the longer you're in the military particularly, it's a very deep sort of feeling of having been rejected by an institution that you care deeply about. And it follows people in a psychological way that it's very hard to describe. But I've talked to people who, were afraid to enter relationships with other people, who didn't want to talk about the fact that they were ever in the military, whose whole lives have been different as a result of this thing that's hanging over their heads. So that's one piece of it. Another piece of it is that for people who are discharged from the 1980s onwards, they almost always have the term homosexual on that paperwork somewhere or another. So again, to the extent that you're submitting this document for anything that you need, you're outing yourself, or you're indicating that someone believed you to be gay, because a lot of people who were discharged were actually straight. So that's another thing that, as from a privacy standpoint, it's deeply offensive to people, and it can also impact their ability to sort of move forward with their lives. So that's something that the Department of Defense has created a path to make changes on those bases. And so one thing that we've been working on a lot at SLDN is kind of getting veterans into a position where they don't have this thing lingering over them, and which allows them to sort of re-access those benefits that they should have been having all along. It's a slow process. It's individually based. So in that sense, there's no sweeping change that takes place for those people. But partly because of the way that the military works, and partly because of the nature of the decision that you're making, it does kind of have to be on a one-on-one basis, because there are people who, a few small number of people who were discharged for other things involved in that, in their quality of service. So that's something that the military is not prepared to move forward on. But so that's one piece of it, but it's kind of more retroactive. The other piece is really about getting to a place where service members who are gay, lesbian, or bisexual are on equal footing with service members who are heterosexual. Right now, they have open service, which means that you can join, you can love who you want to love, you can talk about that person, but they don't have the same status as a married person who is in an opposite-sex relationship. Basically, what this boils down to is DOMA and benefits. If the basic contract that you're making when you join the military, there's a bargain that you strike, which is that you are prepared to lay down your life, sacrifice your health, risk everything that there is in your life to serve your country. And the flip side of that is that the military pledges to make sure that you and yours are taken care of. It's a very big deal to kind of make that kind of sacrifice, and to not have that security would make it a lot harder to do. So for people who are currently serving right now, if you're heterosexual and you're in a marriage, your family has a whole host of benefits that are available to them. Everything from being able to get a VA home loan to being able to just get on base and, shop at the commissary. It's a very vast kind of structure of benefits out there. And most of those aren't available to people who are in same-sex marriages. So that makes their lives a lot more difficult, both on a daily basis and both in terms of these major kind of life changes that end up happening. Right now, what we're doing to kind of push the ball forward on that basis is we filed litigation in Massachusetts. It's at the district court level right now, and there are 8 couples who are all in same-sex marriages and who all are facing problems as a result of the current situation. The litigation is challenging DOMA, as well as the way that spouse and certain other terms are defined within certain statutes that govern military benefits. But it can seem a little dry to talk about benefits in the abstract. So what I want to do is just kind of introduce a couple of our plaintiffs to you, and you can kind of get a sense of how it affects their daily lives. But so I don't know if people can see, but this is the McGlothlin family. So Major Shannon McGlothlin, that's her right here, is a member of the Army National Guard. She is married to Casey, and she's been in the military for 13 years. They have their 2 adorable children right there. They're twins, and they're about to turn 2 this year. So Casey is a housewife, and she takes care of the kids, and the kids are recognized as Shannon's dependents, which means that they have military ID cards. They are able to get on base and take advantage of a lot of programs that are available for family members of service members. to sort of, health and wellness things, activities, entertainment. But Casey isn't. So what that means is, practically speaking, Casey is going to be the one who's going to drive the kids there, who's going to take them on base. But she can't do that because she can't get on base. Similarly, she can't, shop at the commissary. She's not on health insurance. There's a whole kind of host of things that sort of shut her out from a lot of the ceremonies and programs that are available to service member spouses. So it's difficult for her to be part of this community. In a lot of ways, they're just in this second-tier status and not accorded that same recognition. But they're actually one of the happiest cases we have. This is the Ross family. So there's Lieutenant Gary Ross, who's a member of the United States Navy, and his husband, Dan. Gary and Dan have been together for almost 12 years now, and they got married a year ago today at 12:01 a.m. They were the first couple to get married after Don't Ask, Don't Tell repeal. So Gary has served for 17 years, and he's currently stationed in Louisiana. They're originally from California. If they were a married couple, for the purposes of the military, they would be recognized as being able to get moving expenses so that Dan could join Gary in Louisiana, but that's not an option for them because their marriage isn't recognized. Additionally, Dan has some long-term medical problems for which he needs to seek regular treatment. If he were considered a spouse of Gary's, then he would be able to get access to TRICARE and be able to go to a naval hospital and get his issues sorted out on a regular basis. Unfortunately, that's not an option for them. And so since they can't afford treatment outside of that medical system, Dan has to go to Mexico every time he needs to see a doctor. So that's, obviously an incredibly inconvenient and expensive trip to have to make, in addition to actually having to pay for treatment in Mexico. The other thing is, increasingly, it's starting to feel very dangerous for them. Over one of the crossings, Dan actually was witness to a gunfight that took place on the border, and many people died in it. So whether or not that's something that he can expect in the future, it's a source of major tension for the couple, and every time he has to go get treatment, it's going to be something that Gary's going to be thinking about, and obviously that makes it harder for him to kind of really commit to this job when he doesn't really know what's happening to his husband. So this is the Snyder Hill family. Major Steve Snyder Hill, I don't know if you remember, in the Republican primary debates, there was a service member who called in and asked a question about Don't Ask, Don't Tell. This is him. He's been a member of the Army Reserve, and he's been in the service for over 18 years now. He's currently deployed in an undisclosed location in the Middle East, and he has a chance to talk with Josh, through the regular means. But if something were to happen to him, if he were to be killed out there, Josh isn't recognized as next of kin, which means that the military would not give his body to him in that event. He wouldn't be able to do a burial. He wouldn't be involved in that process. He would get information indicating that something had happened, but he wouldn't be the first to know about it. It would be other next of kin. This is the Morgan family. Chief Warrant Officer Charlie Morgan, that's her right here, is a member of the New Hampshire National Guard, and she has been in the military for 16 years. She's been with her partner Karen for 14 years, and they are married, and they have this daughter here, Casey Elena. In 2009, Charlie went through breast cancer. She was diagnosed, she went through several rounds of chemotherapy, and eventually had to have a double mastectomy. But it seemed like at that point things were going to be okay, it was going into remission. In 2011, it came back. She's not going to make it. It's stage 4. She doesn't have a lot of time left. Ordinarily speaking, if you're a member of the military and you die, your partner is entitled to survivor benefits, which obviously are a huge financial bump to help you kind of get through this very difficult time and to make it as a single person. But their marriage isn't recognized, and therefore there's a very real question in Charlie's mind what her family's going to do when she passes on. In addition to having to deal with the fact of your mortality and the fact of your sickness, that's not something that they should have to deal with, and they are. So those are a couple of members, and there's more stories, and I could tell you about them. But the reality is that there's all kinds of ways in which this affects your life. It affects housing allowances. You have to live on a much smaller stipend than most other people would if the marriage was recognized. There's VA home loans for widows and for people who are veterans. There's just a whole host of things. And small ways and big ways in which this can affect your life. And so right now, the case is at a stay. It's waiting on a decision in the Gill case, which I'm not sure if people are familiar with, but it was another challenge to DOMA that took place in the same circuit. And it's up on appeal. There's a good chance that it's going to be taken by the Supreme Court this term. So if that happens, hopefully we're going to see some kind of a positive resolution for these cases in the relatively near future. But that's the reality of what people are dealing with, and it does really kind of cut against the basic grain of what the military's been about for most of the 20th century in terms of integration, in terms of sort of having that base of treating everyone in the same way. And yeah, that's kind of where we're at.
You know, one of the other issues that's come up post-repeal is reinstatement of people who were discharged. The new law does not allow specifically for that. It says they are free to reapply. So 2 of our witnesses at our trial did that and ultimately had to file a lawsuit to help them get reinstated. One fellow was told that he had to lose 20 pounds to be reinstated, and he said, I'm the same weight as I was when you kicked me out. And they said, no, but you're 20 pounds heavier than you were when you first signed up. So he had to take care of that. Another was an officer for 20 years, and they didn't quite know what to do with him, where to put him. In a military that is shrinking as wars wind down. So those 2 are being handled on an individual case-by-case basis. One of the other things that's important to think about, though, is did the repeal do anything to weaken the military? Okay, we're a year into it. And the first study about this has come out from a think tank called the Palm Center. And the Palm Center had previously studied how repeals of similar laws in different countries affected the militaries of those countries, and they had predicted that a repeal of Don't Ask, Don't Tell would have no impact at all, no net impact at all. And those witnesses also testified at our trial. So their study shows that military readiness of the United States Armed Forces is not at all affected by the repeal of Don't Ask, Don't Tell. And that's because the homosexual members of our armed forces have just gone back and done their jobs. And it has not been a big deal. It's a non-event. And they studied it in different ways. They looked at unit cohesion. They looked at troop morale. They looked at some of the things that people had worried about, whether we would be able to retain our armed forces or people would leave in droves once they knew they were serving with homosexuals. That didn't happen. They worried about whether people would continue to enlist if they knew they had to serve with homosexuals. That turned out not to be a problem, too. It's just been a non-event as far as the performance of the military is concerned, as people had predicted. There are a number of sort of bright spots, too, I think, that are worth mentioning as this has gone on. There are now, for example, LGBT groups at the service academies. One of the photographs that was widely circulated was a first kiss photograph. So when Navy ships come to port, there's a raffle, and the winner of the raffle gets to be the first person off the ship, and usually you run and leap into the arms of your loved one and give that person a big kiss. So, last December, a lesbian woman won the raffle. When her ship landed at Virginia Beach, she was the first one off and ran down the gangplank and gave a big smooch to her girlfriend. And that was widely disseminated. The president had some of the LGBT service members as his guests at the State of the Union address. There are milestones like this. There was this June, in combination with Pride ceremonies, the Department of Defense and the Pentagon participated in a Pride ceremony with LGBT troops. That was a first. People were allowed to wear their uniforms in a gay pride parade in San Diego last July. You may have seen some photographs. We now have an openly gay woman general in the Army. and she was pinned on one shoulder by her father and on the other shoulder by her partner. And one of the things that's also interesting now is that while Don't Ask, Don't Tell was a prominent subject featured in the Republican presidential debates in the primary season, it is now not an issue at all in this coming election. It's really not part of the Republican Party platform, and it's just sort of a dead issue as far as the election is concerned, and that really has been a surprise to a lot of people. So there's a lot of positive things that have happened along the way, too, in the year since Don't Ask, Don't Tell was repealed.
Kind of going off of that, the other thing in terms of the way that things are happening socially within the military, previous to Don't Ask, Don't Tell repeal, there were ways for service members to meet each other. There was a secret group on Facebook, OutServe, which with the repeal has seriously expanded, and being able to be above board about who you are is allowing service members to meet each other in ways that they never knew, and to kind of form their own groups and to be there to support each other through what are admittedly slightly different circumstances for people who are in same-sex relationships as opposed to opposite-sex relationships. So that's really great on sort of a grassroots level within the military to be able to have that opportunity and access to other people who are going through the same thing as you are.
I want to thank the panelists very much for their initial presentations. We almost are out of time, but does anybody have a question they'd like to ask?
Oh, we're not grading you. Come on.
What happened to the 10% of people in the active duty survey, and I think it was 2008, who said they'd get out of the military if gays were welcome? What happened to that? Were they just lying, or?
This Palm Center study talks about that, and there are individual cases where people did leave the service because of their beliefs about this, but an equal or greater number of people joined. And of course, we stopped discharging people as well. One of our experts testified that there was we were losing many people who didn't come out and didn't re-enlist and things like that. So what ends up happening is, according to the study, the biggest driver in deciding whether somebody stays in or re-enlists in the military is the amount of the signing bonus. And so that turns out to be the bigger driver than anything else. The other thing that happened about Don't Ask, Don't Tell was the financial cost of all of this, because it takes a lot of time and money to train capable military personnel, and it costs a lot of money to prosecute them and kick them out and to defend lawsuits and all this. And so the estimates are in the hundreds of millions of dollars as to just the financial cost of Don't Ask, Don't Tell. And we were happy to add to that in our log cabin Republicans case by winning a motion so that the government had to pay part of our attorney's fees.
Question.
I was just wondering, how would the implementation of President Obama's health care plan potentially alleviate some of the burden on spouses who are not currently covered by military veteran health care plans? Would it affect them at all? Is there any kind of sort of assistance or relief they could seek there, or is it not sort of touch on their situation?
So, and I'm not an expert on the healthcare issue, so I can't say this definitively, but my understanding of it is that the way that Obamacare is going to affect you is going to have a lot to do with what your other situation is. If you're a housewife, your situation is going to be very different than if you are employed in some other kind of capacity. Obamacare does a lot of really fantastic things. It prevents existing insurance groups from being able to give a limit to how much care you can receive. It prevents you from being kicked off of plans or refused for plans, but at the same time, you still have to pay into a plan of some kind. So most of the time, and again, my understanding is a non-healthcare person, most of the time, if you don't have health insurance of any kind, the fact that Obamacare is there, I'm not clear on what effect it's going to have on somebody who's in the situation where they're not recognized. But I don't know. Do you know more about this?
No, I think that's right. I think the bigger problem remains that because it's part of the federal government, the military cannot by law recognize marriages because of the Defense of Marriage Act. And that creates all these problems she's discussed about housing and benefits and things like that.
I want to get back to the politics. You mentioned, well, we know the Justice Department is no longer defending DOMA. Will the same be true in a Romney administration?
You know, we don't know. We were perplexed, frankly, in our litigation that the Obama administration continued to fight us tooth and nail. And because, I think, the president wanted to be the one who could take credit for repealing Don't Ask, Don't Tell, and to fundraise on that basis. But it's not at all clear what happens to the Defense of Marriage Act in a new administration. I would assume that President Romney would seek to uphold it.
The other thing to keep in mind is that just because the department is not actually actively working in these litigations doesn't mean that nobody is opposing them. Right now, in our case, it's BLAG who's doing it. So that is still the bilateral, the bilateral legal, I think it's advisory committee to the Congress. So they're sort of,
Congress hired
Congress is defending DOMA. Yeah, Congress is defending DOMA.
So that's happening. So from a practical standpoint, in I think some of the smaller cases, it may not be as much of an issue, but in the impact cases, I don't know whether it would really make a difference either way. Someone is still there.
Won't you join me in thanking our panelists for that?
Produced by Duke University. Online at duke.edu.